Contracts, agreements, the cornerstone of any business. But contracts lead to conflict when they are broken or when there is a disagreement between the parties involved. How effectively can these differences be addressed? How can we streamline our system so contracts can be enforced with minimal effect? When there is any kind of commercial dispute, both parties turn to our judicial system, which often leads to a long, drawn-out, expensive process. The average time to resolve a commercial dispute in India was close to 4 years. And so, the Department for Promotion of Industry and Internal Trade is coordinating with Department of Justice for implementation of reforms to make this system easier to navigate. A huge first step in simplifying the system was the passing of the Commercial Courts Act in 2015. This allowed for setting up of dedicated commercial courts in India at the district level and state level. Earlier, there was a manual allocation of commercial cases to judges. This left open the possibility of parties questioning fair play in the allocation of their case to a particular judge. Now cases are randomly and automatically allocated, thereby ensuring greater transparency. Mandatory pre-trial conferences or case management hearings have been introduced. Here, all parties involved, judges, lawyers, and litigants are able to set the timelines of various stages of the case. This helps in reducing time taken for cases to resolve. 2 new apps have been created: the e-Courts Services app for lawyers, litigants, and the general public, and the Justice app for judges. The e-Courts Services app and the website ecourts.gov.in provides 7 services. The e-Court Services app is now in use in over 21,000 district and subordinate courts across the country. There have been over 40 lakh downloads of these apps. Using the Justice app, it is possible for judges to access critical tools like accessing laws, viewing court orders and judgments, viewing and managing case documents, sending notifications to lawyers, tracking the status of a case in a judge's docket. More than 13,000 judicial officers have downloaded Justice app so far. Many other processes have also shifted online, e-filing instead of manual filing. With this, time frames have been reduced by over 60%. Payment of all court fees can be done online. Summons can also be served through SMS and email. The Arbitration Council of India has been set up to promote alternate mechanisms like mediation, arbitration, and conciliation. In the case of an arbitration, an arbitrator is appointed by mutual agreement of parties to preside over the disputes. This helps keep the process more contained. Pre-institution mediation, where parties can work out a mutually acceptable solution with a mediator, is mandated before resorting to conventional litigation for all commercial disputes. All these reforms have made the process of seeking justice more efficient. In the last 6 years, India's rank has gone up by 79 places. As per Doing Business Report 2015, India's rank was recorded as 142, while in Doing Business Report 2020, it was recorded as 63. Reforms under all indicators have contributed towards this growth. This is a journey. Much more can be done to improve the system. But we are moving in the right direction, facilitating ease of doing business, making our economy stronger. The Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India